This hour of news and views is sponsored by Africa Muslims Agency. Africa Muslims Agency, a beacon of hope to communities for over 35 years in Africa and beyond. Still to come in the next 45 minutes shortly, specialist immigration attorney Ashraf Isop will be joining us. We're talking about the 95 Libyan nationals who were arrested at a suspected illegal military training camp. You will recall we covered this when the story had actually broken out, and since subsequently they've appeared in court. We will talk about that shortly. Also, we've got fired up with Hafiz Imran Chunara, a personal excellence mentor and CEO of Africa Muslims Agency. We will be talking about a picket in commemoration of the martyrdom of Ismail Hania, rahimahumullah, and the Caesar Al Quds Foundation in Cape Town. And towards the end of the broadcast, we will be taking a look at 3 years of the Taliban rule in Afghanistan. But right now, going across to be joined by specialist immigration attorney Ashraf Esop. Ashraf, assalamu alaikum wa rahmatullahi wa barakatuh. Juma Mubarak and welcome to you.
Walaikum salam wa rahmatullahi wa barakatuh. Juma Mubarak, and thank you once again for the invitation.
Yes, Ashraf, the last time you and I spoke, and you obviously expressed great concerns with regard to what had actually happened with the 95 Libyan nationals. It was a major story, a huge story, talking about illegal military training camps and the like as well. And we've seen subsequent to that, the men have appeared in court. And now we learned even Home Affairs is moving very, very quickly to deport these 95 Libyans after the state has withdrawn the case against these Libyans.
Yes, that's correct. That's before they appeared, and there was a lot of uncertainty. And obviously, they've now been, they've been in court and they followed the legal process. And we now hear that the Department of Home Affairs has consented to the deportation in conjunction with the National Prosecuting Authority withdrawing whatever charges that were put to the accused. As I understand it, this was due to representations that were made by the defense team. So we're now waiting to hear what the next step would be and how it would be adopted. But I think one needs to really get a clear understanding of what deportation means. So deportation is essentially a unilateral act of South Africa to get rid of what they refer to as undesirable aliens or foreigners. And the purpose of deportation is achieved when such a person leaves the South African territory. And very importantly now, the destination of the deportee is irrelevant for the purposes of deportation. Now, why am I emphasizing that? Because there was actually a famous case that informs us how these things work and why it is so important. So, in the normal Immigrations Act, deportation is dealt with thereunder. But if it is a refugee, then the Refugees Act and the international protocols that we've signed militate against the removal of the person from the Republic based on the principle of non-refoulement. Now, non-refoulement is you're not going to be sent to a country where you face death, torture, or other kinds of harm. So refugees are protected from being removed from the Republic by such a principle. Obviously, they've entered into the Republic on asylum-seeking permits, and they may or may not ultimately qualify for refugee status. But it's very important that we appreciate the difference between the laws that are applicable to asylum seekers and everyone else. Now, when you are arraigned for deportation, it's necessary for you to be detained pending the departure. And very important issues arise regarding their detention. There's certain rights. I mean, we've heard that they've complained about the kind of treatment, the food, the hygiene that they've received as people that were detained on immigration charges. And I'll visit that shortly as well. But very importantly, as far back as 2001, in the Constitutional Court of Mohammed versus the Minister sorry, not the minister, the president of the United States, of the Republic, which dealt with the issue of the constitutional rights of foreigners when they were imported. In context, Mohammed was a Tanzanian national, and he was sought by the U.S. government as a suspect on capital charges regarding the bombing of the U.S. embassy in Dar es Salaam. He was actually traced to Cape Town, where he was living under assumed name and a false passport, and he was arrested as an illegal immigrant by South African immigration officials. So that's the first distinction. He was not here seeking asylum. He was here on a false document. Now, there the Constitutional Court had occasion to deal with what is the difference between extradition and deportation. Extradition involves, act of sovereignty, and as we saw in the Bushiri case, there are certain documents that need to be handed in, certain applications need to be made. For deportation, it's a completely different thing. Importantly, the court found that the state lacked the power to determine where the person would be sent once they are deported. Remember, there's illegal rendering as well. You recall the matter of Jibai many, many years ago, where the person was illegally rendered out of the Vaterkloof Air Force Base back to Pakistan. But that was because there was no due process followed. And ultimately, we don't know what happened. I think Jibai then resurfaced in Pakistan, and that's where he is. The power to deport is not in the Constitution. It is only found in the Immigration Act and its regulations. And in this case of Mohammed, the United States was not a destination permitted by the regulations simply because he faced the death penalty. So that was an important consideration. Now, the South African Constitution has imposed obligations on the government to protect the fundamental rights in the Bill of Rights of all persons, and especially where deportation involves the possibility of capital punishment. There was a situation where there was a murder committed in Botswana, and that national had taken up refuge in South Africa. And his basis of being deported or sent back, his defense was, look, I faced the death penalty there and I need you to protect me. So the only way that the South African government could attend to deportation was to obtain an undertaking from the Botswana government that that particular individual will not face the death penalty. Now, in Kazu, in this matter here at present, as we know it, we told that they will be sent back to Libya. So that throws up a whole lot of questions. Now, why, how did they get here in the first place? Who is really the actors behind the scenes? Who applied for these study permits? And ultimately, where will they be sent back? If they sent back to the national government of Libya, for example, who sent them here? What if the opposition sent them here? So you could see that it throws up a lot of important questions. Now, we are not the advisors or the defense team, and we don't know what advice they were given, but you certainly need a whole lot of documentation for you to understand what's happening to you. Previously, Section 34 of the Immigrations Act said that you could be held, beyond 48 hours, and you needed a warrant to be extended by the court. We know that has changed because of the amendments to the section and the regulations, because they were indeed brought to court within 48 hours. So they enjoyed all of the normal rights, and they were entitled to a legal defense, even at the expense of the state. But importantly, they must be informed of their rights on the arrest, very important in this case, is they must be informed in writing and given certain forms that will accommodate the deportation. Excuse me. In the same section 34, there were minimum standards that were laid down to protect the the detainees' dignity and human rights. There had to be, minimum standards of accommodation. I mean, it's very clear. It says space, lighting, ventilation, sanitary installations, general health conditions. You remember that they were moved from one prison to another. They had to be provided with a bed, mattress, and at least one blanket. This is not in terms of the Criminal Procedure Act. I'm referring to the regulations in the Immigrations Act itself. And they could have health issues and security risk issues, and they should be separated from everyone else. And there can be a deviation from this standard from a particular detention center, and they provided that it is for medical treatment or some other reason. Nutrition, very important. They had to be given a balanced diet. And it says that, the diet must make provision for pregnant women and children or other categories of detainees whose physical condition requires a special diet. So that would be, say, for people suffering from diabetes, etc. Here, you would notice that there was no provision for a religious diet. But I would submit that the Constitution won't allow a discrimination on that basis. They're entitled to a medical officer, clean drinking water, hygiene, and he was allowed to keep his person, his clothing, and his bedding in a clean and tidy condition. So those were in terms of the regulations. Now, in the event that they are deported, then Section 29 of the Immigrations Act kicks in, and it says that you may make representations in Section 29(2) to the Director General not to be declared a prohibited person, and after a period of 5 years, apply for readmission to the Republic, and certain documents you'll have to give, like an affidavit, etc., etc. So, you can see that this is quite a complex legal problem or issue, and the Constitution demands proper legal protection for all detained persons. And it's important that when there is an actual act of deportation, they have to, allow, or they must follow certain procedure. And they may even order the detainees to deposit a sum of money to cover the whole or part of the expenses related to the deportation. So it's important to know who exactly is in charge of the financial affairs of these people, because where there's a failure to comply, there could be criminal offense, a fine of 20,000 rands, and imprisonment not exceeding 12 months. And they also, when enforcing payment of the deposit, must serve certain prescribed documents in terms of the Immigrations Act. So this again deals very specifically with the law regarding deportation, the kind of documentation that must be used. And if the documentation is not used, then we can say that there was non-compliance with the Immigrations Act, and basically there are consequences for that. So I hope, just as an introduction, you're following what I'm saying.
Well, Ashraf, I must say for me, this has been an education on its own. And, I don't think many of us realize the complexities from a legal perspective as to what all of this means. So, it's been most useful, very, very valuable information that you provided, particularly looking at it from a legal perspective. But what we've also learned with these 95 people is, and according to reports, saying that this is now a case of deportation, where one of the reports talk about the man had actually made representations and have actually applied to be deported to Benghazi. That so going back to Libya, but also looking at the way the manner in which this case was actually publicized, and having learned from the NPA that the state had withdrawn the case because the docket showed that there was no prospects of a successful prosecution. Now, this is extremely important because, again, when you look at the deportation, the reason given for the deportation has been misrepresentations on the South African visa applications.
So that's part of the mystery. I don't know if you recall during our first conversation, there was very little information as to what exactly was the misrepresentations. We understood this to be study visas, and they said they're coming to study at a particular institute. That institute was registered with SIRA to provide security training. I think the only difference is what kind of training they received in the end, and there's some debate about whether this was military training or not. Of course, we were told that there's military style camps and tents and what soldiers are generally used to. But at the end of the day, I think that the state was faced with one crucial and very, very important point, which they would have had difficulty in proving, and that was intention. So, you have an act. For every crime, you have an intention, an animus, and then the act. I think the most famous case recently is that of Oscar Pistorius. There was a whole debate. People in the street were talking about dolus eventualis and directus. This is all the meanings attached to intention. And I think there the state would have had difficulty in proving that the applicants or the accused had intended to breach the Immigrations Act. Now, none of the document is made available to us. We know they applied in Tunis because we don't have any presence in Libya. That is in terms of the law. They must have filled out the normal application for a study visa, which includes proof of financial means, a letter of acceptance by the institute, and proof that you have a medical aid while in the Republic, and a study visa is extended to you for a certain period of time. Now, it's quite commonplace. People come from abroad and they say they want to study English in South Africa, but very popularly they come to study as pilots, student pilots, and obtain their private pilot's license. So all that is commonplace. And I mean, there's nothing untoward. So as I say, I'm just guessing, I'm giving a non-binding opinion that probably the state realized, look, we cannot prove that they intended to breach the laws of the republic because they had not visited the institution before the study visa was issued. So they must have said, look, we're coming for this, and basically that's what it amounts to. Now, in terms of the Criminal Procedure Act, the defense is entitled to make representations to the state to say, look, withdraw the charges, there's no prospect of success, and they would put a debate on paper. The senior public prosecutor will be entrusted with looking at it and making a decision that says, we don't want to waste time, we don't want to waste resources, let's withdraw the charges. That's one side, that's in terms of the CPA. Now, what happens to persons in the Republic who were here on a visa? Remember, one of the first things we heard was the study visas were cancelled. Now, once it is cancelled and you don't have any other rights in the Republic, then deportation follows. But as I've explained earlier on, deportation is a very specific way that is set out in the immigration regulations, and it has to be followed. And for us right now, we know a deal has been struck. NPA has withdrawn the charges. Deportation processes are now underway, and we don't know, and we're not even told, and they're not even obliged to react to where exactly these people will be sent.
Yes, Ashraf. And also, just finally, looking at Home Affairs, and it appears as if they want to get over this entire saga as quick as possible, because we have learned that Home Affairs wants to move very quickly with regard to the deportation of these people.
Yeah, that's a correct approach. Remember, we spoke about places of detention, minimum standards. Then the detainee has to pay a certain amount for the deportation. And again, to hold them in incarceration or in Lindela, for example, pending their removal from the Republic, will just make things very, very difficult. It's commonplace where there's a deportation and the state is provided with a airline ticket or guarantees for the passenger, then the department moves with speed. It's in a normal course. This is not something extraordinary in this case.
Okay, Ashraf. Jazakallah khairan so much for that, really. And as I said, this has been quite an education, because, we hear about extradition, we do hear about deportations as well. And Alhamdulillah, you've unpacked it just so well, actually, and just gives us a much deeper insight, into how this entire system works and how the legal system actually works. And also unpacking what you have with regard to these 95 Libyan nationals as well. Jazakallah once again. Have yourself a wonderful Jummah, inshallah, and looking forward to future engagements as and when these matters arise, inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam wa rahmatullahi wa barakatuh, and Jummah Mubarak to you and the viewers.
Ashraf Essop, specialist immigration attorney, with us this morning. And I must say, it's been a fascinating discussion, just unpacking what has happened to these 95 Libyans, but also providing us with a deeper insight into what immigration law is all about in this country. The time is just gone 9:36. And remember, we've still got the commemoration of the martyrdom of a Shaheed Ismail Hania, a picket at the U.S. consulate, with Haji Yunus Ali coming up as well. But next up will be Personal Excellence Mentor, CEO of Africa Muslims Agency, Fired Up, with Hafiz Imran Chunara. And remember, this hour of News and Views is sponsored by Africa Muslims Agency. Africa Muslims Agency, a beacon of hope to communities for over 35 years in Africa and beyond.